told a couple people that we would record. So I'm going to record this. But we've got our technical assistance providers for the firearms grant, because I don't think they're aware of some of the weird challenges we have in Arizona with protective orders. So it would be good for them to know what we're up against and why we're designing our things the way we are, so they can help us better. So thank you all for coming. I'm going to share my screen and start. And then if you have questions, please feel free to interrupt and ask me, but I probably will get distracted. So you need to talk if you are doing that. So wait, let me go back a second. So the reason, so this is not a judge's training. I know I've got 1 or 2 judges that signed up, and I just want you all to know this is not a training that I would give to judges, because there's a lot more rules, a lot more details, and I certainly can answer any questions you have, but I kind of wanted to make it an overview for everybody to see what happens. What do survivors do when they have to go get protective orders? How does the system work in Arizona? So that's where we are. Now, ARPOP are the Arizona Rules of Protective Order Procedure. I am the head, I'm the chairperson of CIVIC, which is the Supreme Court's Committee on Domestic Violence in the Court, and we are responsible for drafting the changes to ARPOP. And we've done a lot of drafting over the years that I've been in CIVIC. So just to address weird things that come up and issues that arise. So included in orders of protection, they're all called orders of protection under ARPOP, but there's 4 different categories of protective orders. There is domestic violence orders of protection. Sorry, I was trying to shut my chat. There's domestic violence orders of protection. There are injunctions against harassment. There are injunctions against workplace harassment, and there are lifetime protective orders. And lifetime protective orders come out of Superior Court, and they we don't deal with them. In CIVIC, they are a different kind of beast. So those are a different kind of thing. So mostly I want to talk today about domestic violence protective orders. And I know, like I said, I have a really diverse audience. So some of this stuff I will talk about, but it's not in a PowerPoint. I know police officers, my lawyers all know what relationships are included in domestic violence definition in Arizona. But not everybody does. Basically, in Arizona, the domestic violence relationship that would be covered by the criminal law and covered by the protective order law is, and I'm going to just read it to you quickly, marriage or former marriage, or live together now or in the past, a child in common, one is pregnant by the other party, and then relationships up to basically aunts and uncles don't count, right? So you've got mothers, brothers, sisters, step brothers, sisters, grandparents. It stops pretty much at aunts and uncles. So anything up to that point is domestic violence relationships. And a romantic or sexual relationship. And then the statute gives us factors to decide whether or not there was a romantic or sexual relationship. And I know this has come up in the past. I know with the U of A advocates who are here, I've talked to them about that. We have to decide when there's a sexual or romantic relationship, and looking at the factors of the type of relationship, the length of the relationship, the frequency of the interaction between the victim and the defendant, and if the relationship has terminated, the length of time since the termination. So that's kind of a judge's call on whether or not there's a domestic violence relationship, or whether someone might have to change their protection order and apply for an injunction against harassment. In a protective order, there is an ex parte hearing first, and that means that the plaintiff can come in, talk to the judge on the record, preferably, but not required, and fill out a petition and get that order without the defendant being present. So we'll go in through that a little more. I also think that people get confused sometimes about harassment. Harassment and an injunction against harassment. And I sent you those definitions, and I would like you to make sure that you go through those, because we actually have 3 different definitions that we put into ARPOP because people were so confused. Harassment for an injunction against harassment. No relationship means a series of acts has to occur. Harassment in a workplace injunction, you only need 1 in certain circumstances. And harassment in a criminal domestic violence protective order. So in a protective order where there's that domestic violence relationship, a judge can find 1 act if it fits under 1329-21. So they can find harassment if it fits under that definition of criminal harassment. So it's different than it would be where we have to find a series of acts for a injunction against harassment. And speak up if you have a question, please, because I can't see you right now. So everybody's probably familiar, or at least the Arizona people are familiar with AZ Point. AZ Point was developed and actually went into effect like right before COVID. And it turned out to be like a great, great resource. So I was one of the people that was kind of skeptical about it, but I think that it's proved itself. You can go on this website, you get a password, it reminds you to make sure that you're picking somewhere that you can get safe emails, because and there's a lot of safety information on the AZ Point website. There's a lot of things that help plaintiffs figure out, hey, is this safe? Where is this email going to go? I don't want anyone to see that I've done this. So this allows people anywhere in Arizona to fill out their petition and save it, and they could go back in and amend it. They can decide never to follow through with it, but they can file their petition. Before COVID, we used to have video protective orders from Emerge. They had a screen set up, and I don't even know if we do that anymore because it's so easy now to do this way. And you can call into the courthouses and talk to a judge by the phone. So, but AZ Point has also, raised issues with the way orders are served. And so that's what we're going to talk about today too. So the process, if you are a plaintiff and you want to do a petition, one, you can look on the court's websites. I know all of our courts have links to AZ Point and also offer that you can come to court to fill out that petition. If you fill that petition out and for some reason you don't want to come into the court or you can't, you can call the court and set up a hearing over the phone with the judge. And I talked to Judge Harris over at Superior Court. She does the protective order hearings there. And she said she does those over the phone in Superior Court too. Judge Wilson can tell us if they do it there in Justice Court, but I'm assuming most people do now will take those petitions over the phone. So I can swear them in over the phone. I can pull it out. So the clerks, they will call the protective order office and give the clerks their number that's been assigned to their petition. And the clerks either print it out for me to talk to them as the judge, or they print it out for us to call them back as the judge. And so we kind of have an idea about what's going on before they come in to talk to us. So in our courthouse, if the person comes in, for example, then we swear the plaintiff in. And I know in a lot of courthouses, the clerks do it, but we've always had a policy. We just do it when we talk to them. We have, I think our walk-ins office is like super good for victims, for survivors, because we have an actual office. You can go in and talk to the judge in the office. A lot of courts I know either do it in open court during the session, like we are required to do them in a fairly fast manner. If someone comes in with a protective order, you're supposed to do that within the hour or so, interrupt court, do it when you can. So some people do it during their sessions. Other courts do it at the window. We have an office and we can go on the record there in the office when we're talking to the petitioner. So, and I'm sorry, I go back and forth. It's plaintiff under the orders. So that's under the rules. They're called plaintiff and defendant because this is all encompassed under civil rules of procedure. So as a judge, I would talk to the plaintiff and find out who is this person exactly? Are you still living with them? Did somebody have a question? Nope. Okay. I would ask them, are you still living with them? They fill out the petition. It has those things, but I kind of like to get a little background, not a ton, but a little background on what brought that person there today. So what we've discovered is that a lot of petitioners, a lot of plaintiffs don't always fill in like all the incidents. Like I had a hearing the other day where the defendant didn't show up, but I still had to do the hearing, and they had said one thing about this person. And then when she started talking, she's like, oh yeah, she calls me every day, like 5 times a day. She's doing this, this, this. And I was like, okay, so obviously we need to add that to petition because there's case law now that requires that you can only talk about at a contested hearing what's on the petition. So that was causing problems for plaintiffs. And so one of the amendments that came through a couple of years ago allows a supplemental page that the petitioners can fill out, the plaintiffs can fill out even at the hearing. And they can, and we'll get to that hearing part, but it allows them to add things that they might not have added. But as a good judge, you should be asking, is there anything else? Are there other things that that this person's done to you? I need you to fill it out. This person needs to be served with all this information so they're prepared about prepared if they want to have a hearing to contest this. Another important question to always ask is, are there other orders? Because a lot of times people get served with an order and then come right back in and get their own order, right? So you want to know. We also, as limited jurisdiction judges, need to ask about whether there's a family law case, and we'll get into that a little more. So at that point, it's just me and the defendant, me and the plaintiff meeting and me trying to decide whether, and all I have as a burden at the ex parte hearing is reasonable cause to believe that domestic violence has been committed or may be committed. So if I find that, I wanted to address this first because it's through AZ Point. So this is what changed a lot with the AZ Point. When I issue that order, my clerks will put it into the order and it gets sent to AZ Point. AZ Point figures out which law enforcement agency it should go to. And it gets emailed to each law enforcement agency, the right jurisdiction. So I know that the constables serve it for justice court, and I think for superior court, although I was just talking to the sergeant this morning, and he said if somebody calls and wants an order served and the person is in the house with that other person, then the deputies will go and serve that. We used to do that with TPD. If the defendant lived in the same household or didn't have an address, we would give the plaintiff that protective order and tell them to call the police to have it served. That's one of the issues we're working on now with Tucson Police Department. Obviously on the cases where people are going to be ordered to turn in firearms, and on the cases where people might be living in the same household and it would be dangerous for a process server to do that. We're hoping to work on that. TPD's been really supportive of this under the FTAP project. So we're hoping to work on that issue. But TPD right now it goes right to a process server, and the process servers serve these protective orders. There is a requirement under the rules that the agency that is attempting service shall notify the plaintiff if they can't serve after 15 days and then continue to attempt service. That, I think, like how many times are they required to attempt service? What does that mean? I always hear they try 3 times. So I'm not sure how that's being followed, but I understand that, that manpower is an issue everywhere. So you're not going to keep trying to serve it forever. So that's one issue that is not always resolved the way I think probably plaintiffs would want it to be, to keep serving it forever. So what can we order in these protective orders? We can order no contact. We can order no return. We can check a box to allow for return with law enforcement for belongings. We can order no return to other locations like schools, workplaces, shared places, babysitters. A lot of times, the parents who might be babysitting, like grandparents, things like that. I always try and train judges to be really careful with like shared places, like bars or churches or things like that. I also train judges, don't put like the University of Arizona, because that's like a really big place, right? So we try and make it, a little more narrow so that we're not, having someone who happens to be on one side of campus and the other person never goes on that side of campus. So I ask a lot of questions when someone wants these big orders, these big general orders. We can order exclusive use of the residence. If the defendant wants a hearing to contest that order and we've ordered exclusive use of a shared residence, then it has to be set for hearing within 5 days of the request. And at that hearing, we need to consider that this can't go on forever. So let's say if it's shared, it could, but if it's like the defendant's house, right? And he got arrested and the victim's staying there, the plaintiff's staying there, I am within the rules to say, okay, you have 30 days to move out. I can consider who owns that house at that hearing if I'm making that kind of determination. The plaintiff can also add protected persons. And usually I train most judges, don't include other adults. Sometimes if they're vulnerable, like sometimes you'll have like really old parents living with the plaintiff and the person has kept coming to the house or keeps calling the house. So they're feeling the effects of this. Or the person I always use as an example with the judges threatens to burn down the house and those people live there. I will add those old people, like vulnerable people, even if they're adults. I won't add people's boyfriends or things like that. They can come in and get their own order, probably an injunction against harassment. But again, I try to train judges, you need to be narrow with these orders. Our purpose is to protect the plaintiff and protected persons who, are legitimately includable, but not to like keep that person from doing anything, going anywhere. We can also order a no contact with any animals owned by the plaintiff. That comes up more than you would think, but obviously it's a risk factor in DV cases, is that threat to animals. Does anybody have any questions so far? I'm whipping through this. Okay, so let's see. I want to talk about, which way did I go? Kids in protective orders. So this is really a sticky part. So if there's no legal relationship between the defendant and the child, like it's the plaintiff's kid and she was living with the defendant and she wants an order, I can just add that kid onto the order without a finding of DV, just because the defendant has no legal relationship between him and the child. So that one's easy. I don't have to find anything. If there is any kind of legal relationship between the defendant and the child, I cannot include that child as a protected party unless there's reasonable cause to believe that physical harm may result or has resulted to the child, or the alleged acts of domestic violence involve the child. And there's no definition of what involved means, and that's part of the statute. So that's where I think people differ, judges differ. Like, I know that witnessing domestic violence or being in the house where there's domestic violence happening certainly impacts the child. I've seen other judges in my courthouse do that as a condition of release in a criminal case, no contact with the kids, when the kids were there when this happened. They weren't, the violence wasn't directed at them, but they were there. And some of the judges in this courthouse, I know, include the kids on conditions of release. I don't like it, but I think that we need to be careful as limited jurisdiction judges to adding kids in protective orders. So usually you will see that a limited jurisdiction judge is pretty careful about adding kids, unless I'll add a kid if someone has been threatening to take them to Mexico and you'll never see them again. I'll add a child if obviously they were in the way, like they were there when things were being thrown, or the victim was holding that child when the violence occurred. But just for being there, I usually won't add a child. And I think a lot of judges think that way, but I think it's a difference of opinion. So I want to talk about firearms, because obviously part of this is for my FTAP group. So on domestic violence orders of protection, a judge in an ex parte hearing, the hearing just with the victim, must inquire about the defendant's use of or access to firearms to determine whether the defendant poses a credible threat. So that's my burden. I have to decide whether the defendant poses a credible threat. With such a finding, I may prohibit the defendant from possessing, purchasing, or receiving firearms, and I can order him, and it's all one line actually on the protective order. So if I prohibit them from possessing, purchasing, or receiving firearms, I'm also ordering them to transfer any firearms to the appropriate law enforcement agency. So the way I teach this in judge school a lot is kind of, and maybe is, I ask the plaintiff, does he have guns? They'll check the box that he should be told not to have guns, but they don't check the box that he has guns. I'll say, do you think he has guns? No, but he has friends that have guns. Well, that's not enough for me, because there's no history of him using guns. If they say, oh, he has guns, but he takes them out to go hunting and they're in a locked safe in the garage, then I probably won't find that that person is a credible threat. If she tells me, yes, he takes out his gun when he wants me to cook dinner and cleans it when I'm not making what he wants me to cook, then that's how I teach it to judges. Then, of course, I will say, okay, this gun is being used as a tactic of power and control, and it's a credible threat to that person. And I will add that to the protective order. So then I have to figure out where that person lives, and I order them to transfer that firearm to some police department or Pima County Sheriff or whoever. And so that's when you're going to end up with an order like that. We have to ask that question in every protective order. And then if a judge has determined that there's a credible threat, that's when you're going to see that order where we're telling the defendant not to possess the firearm. In injunctions against harassment, we have to ask about firearms too. And we couldn't tell them not to possess firearms, but there's nothing about transferring. So, and that's, I think sometimes you get really, neighbors who are really cranky, and they're the hardest cases to have in hearings. And you may indeed want to keep them from possessing firearms. But in those kind of cases, I would really want to know that this person is threatening to do something with a firearm in like a neighbor type of case. So I want my, oh wait, now I'm getting the spinning wheel, so I can't flip. Hold on.
Your Honor.
Yes.
This is Carmen. So I'm just to clarify, I may have missed this. In the injunction against harassment, you could potentially still order the defendant from possessing firearms, but it's not a requirement. Did I hear that correctly?
Right,
Okay.
actually in both, and I was kind of surprised. I went back to the rules. It's still even on the DV orders. It says that oh, there, it says that and now I'm really going ahead of myself. Let me figure out what I'm doing. But even in the DV orders, it just says may. And so
Oh, okay.
I was not, I actually honestly didn't know that, but yeah, it always gives us the discretion to order no firearms. It doesn't require us to say no firearms. So, which I thought was odd because, we've talked about that a lot. We must inquire, but I may prohibit the defendant. And that's the same with injunctions against harassment.
Okay, thank you.
So here's more of a firearms digression here. So here is where everyone gets tripped up. In Arizona, we're like the only state. There may be one other state, I think, in the union that does this. I have an ex parte
Excuse me,
here.
Judge, we're not
Yes.
seeing a screen.
Oh, you're not? Shoot. Okay, let me figure out where I am. Sorry. Let me try and share again.
Yeah.
Thank you for telling me. Okay, now can you guys see it?
Much better. Thank you.
Okay. So in Arizona, a judge can order no firearms and turn in your guns in an ex parte hearing. This makes a defendant a state prohibited possessor for the length of the protective order. In Arizona, we don't schedule automatic permanent hearings on these. So every other state where I've trained with other judges, they will automatically, they'll issue an ex parte hearing and then they'll set it for hearing like within 10 days. And at that hearing, that's when you would become a Brady prohibited possessor. And I'll talk about that a little more. But we have the option of never contesting that ex parte order as a defendant, and you will never become a Brady prohibited possessor. So if you say, oh, I want to contest this and set it for a hearing and don't show up, the federal case law pretty much makes you a federal prohibited possessor, I think. But if you don't set it for a hearing, if you don't request a hearing, that order will stay in effect for 2 years. You will be a state prohibited possessor, but you will never get into the federal prohibited possessor lists, basically. You do become a prohibited possessor on NICS, because NICS is and I can't even remember what it stands for. I know lots of you do, but it's the list where people get listed, and when they do a backgrounds check for firearms buying, if you are a prohibited possessor of any kind, like under my conditions of release in a criminal case or as a state prohibited possessor, you won't be able to buy a gun at a licensed firearms dealer, but you still aren't a Brady prohibited possessor. So because you've never asked for a hearing. And what makes you a Brady prohibited possessor is the opportunity to be heard and the relationship, the intimate partner relationship, which I'll show you on the next slide. So it only applies to intimate partners, so it's less comprehensive than our domestic violence definitions. So this is what we deal with a lot, like with judges sometimes, is that the state courts have no control whether Brady applies or not. There's nothing we can do to change it when it applies. So if I have a hearing, if you've asked for a hearing, and then you come in and you're like, oh, I don't want a hearing. Well, too bad, because you had the opportunity. The plaintiff showed up, and that was the point, that you had an opportunity for a hearing. The fact that you're turning it down, it doesn't matter. You had that point. We only allow one hearing request under the ARPOP, and that's so the victim doesn't have to keep coming back to court over and over again, so that court hearing can't be weaponized against the plaintiffs. So you have one shot. If you don't make it to court, I mean, obviously, if somebody has an accident, we will set it for another hearing, right? But if you just don't show up, or you come and say, oh, you know what, I changed my mind, I don't want a hearing, that's it. You now have become a Brady prohibited possessor if you meet the relationship. So It doesn't have to be a full-blown hearing. It just has to be a hearing opportunity for a hearing. And we can't do anything about it. I can't go in there and say, oh, well, this was not really a hearing because the defendant didn't want one. But judges try to do that kind of thing. So here's what we have. This is our Brady indicator, and it's caused a lot of problems like in the Court of Appeals, because we'll get hearings and then people will say, well, they should have found they were a Brady person. It doesn't, we're not finding they're a Brady person. We're checking these two boxes, the definition of an intimate partner. So, and it's really just a notice to the defendant that you are now could be a Brady prohibited possessor. We just have to find that there was a hearing, that the defendant received actual notice and had an opportunity to participate, and that the relationship matches. But let's say I don't file that. Nobody cares. If they want to prosecute them for a Brady violation, they will prosecute them for a Brady violation. We have that prohibited possessor language all over all of the paperwork for protective orders. So not serving this on anybody, I've argued to get rid of it because it confuses so many people. Not serving this notice on anybody is not going to change the fact that they are prohibited possessors under Brady. Anybody have any questions about that?
Judge Kevin Franklin here, just a quick question. If the order of protection is not granted, but they have the hearing, they still end up as a prohibited possessor under Brady?
No, if they go to a hearing and so there's two different kinds of hearings, right? There is, if I grant an order, an ex parte hearing, that order's in place until it gets contested at the hearing. And if the judge at the hearing finds that it wasn't, that there, because it has a little higher burden of proof for the hearing, it has to be I always can never remember it. I'll find it for you, but it's a little higher burden of proof, right? So the judge could find, oh, this really wasn't whatever, and dismiss it. Then they're not prohibited possessors. It's only when that order is in effect and it lasts for those 2 years. But you could also have a hearing prior to. Hardly anyone does that for domestic violence cases. A lot of times we will do that for injunctions against harassment, like when there's neighbors or just a bunch of people, like, you don't know who's telling the truth. These people are going to contest it. I'll set it for a hearing and not grant it. Then that defendant will get the notice of that hearing. They'll come in, they'll usually file their own petition. They'll come in and we'll just have a whole, falderall there in court where everybody puts on their information. And then I could grant that order right there in court and serve it on whoever needs to be served, or say, no, I'm not going to grant any of these orders. This is not harassment. So the only way you are a prohibited possessor, Brady wise, is if you have the opportunity for a hearing and the order gets upheld. And later on, you'll see that we've actually really clarified who shows up where, what happens to the order, because that's an issue too for people. So this is something that all my lawyers should know. The parties get a ton of information. Served with the protective orders are defendant guide sheets, and the plaintiffs receive the guide sheets when they're applying for the orders. They're in English and in Spanish. They include information about requesting a hearing, the length of the order, the fact that you might become a prohibited possessor. They talk about family court. They talk about children. They talk about how you can contest it. And AZ Point has a ton of information for people. So these things aren't served in a void. They are served with a lot of information on how you can contest it, what it means, what no contact means. And I sent you all of those so you can see that people get a lot of information when they get served orders of protection here. So if there's a family court case, if I get someone coming into city court and they're applying for a protective order and they say, well, yeah, we've got a family court case pending, I say, go to family court, go to Superior Court. So sometimes what will happen, I think in smaller jurisdictions, and that's why the rule was issued the way it is let's say all of Superior Court is closed, and I'm not closed yet for some reason as a limited jurisdiction court. If I think it's, an emergency, this person needs this order, I can issue it and then transfer it immediately. So, I can issue those orders, but if there is a case pending, like it's open, like they haven't decided everything yet, then we should be sending those people to family court to do their protective orders. If there is a family court case, it's done, but there's still like, legal decision-making going on, right? There's visitation going on. I could issue an order in that. I should probably transfer it to family court, but I could issue that order. But I have to be really careful not to step on any of those custody, parenting, and decision-making orders. I can't, for example, say, like, let's say these people haven't gone to family court. I can't say, oh, well, on every Wednesday, you guys have to exchange kids, right? And go to this park and together you must exchange. I can't do that. Now, a lot of the jurisdictions in the other states have like, their judges have like a lot of power. Then they're not family court judges. They can order, like support payments. They can set up visitation. We can't do anything. Our rules say, especially as a limited jurisdiction court, you can only allow contact by email or mail to arrange for parenting time and can arrange child exchanges where the plaintiff is not contacted in person. We can't set anything up. Superior courts can't even use a protective order as a way to set up parenting time. They have to set up separate orders. So we can put up, what we do a lot in my courtroom is you can have contact to talk about the kids by mail or by email. We will do that, but mostly I like to make sure that I'm matching what's ever going on in Superior Court, because we don't want either party to get caught up in okay, which judge said this. And so I think it's super important for us to pay attention to the idea that there might be conflicting orders in these cases, and that we have limited jurisdiction. The limited jurisdiction courts don't have a lot of jurisdiction on these kind of cases. So, contested hearings, if the defendant requests one. Otherwise, we never have a contested hearing. It just gets served. It sits for 2 years. People don't contest it if they don't want to become federal prohibited possessors. Sometimes they've just moved on. So a lot of the orders get served and don't get contested. The other thing that's changed in the last couple of years is domestic violence protective orders are good for 2 years now. Everything else is still only good for a year, the injunctions. So that's different. So now they're good for 2 years from the date of service. If they haven't been served within those 2 years, then they expire. At the hearing, the plaintiff can supplement their petition to add allegations. I emailed that form to you. That's new. That's like in the last year or two. So let's say you went in by yourself, you applied for a protective order, and the thing that struck you the most was what happened the night before, and he got arrested. So that's what you put down, and that's all you put down. And you didn't have a judge that said, well, has he done this before? What else is going on? So and then you get hooked up with a merge, right? And you have an advocate, and they're like, oh, you might have other things that you want to talk about. The plaintiff can now supplement their petition to add allegations. They can do it at the time of the hearing, and the judge can give the defendant 2 choices. They can continue the hearing so that they can prepare to defend against those additional allegations, or they can take a break and let the defendant review those allegations and choose to go forward. So that, like I said, is something that was really useful for victims of domestic violence, because they're not always thinking in a linear fashion. And if they have some help going into those hearings, helping them, then they might be able to come up with other things to add. So it is the plaintiff's burden of proof. They have to put on their evidence first, call witnesses if they have any. I always tell plaintiffs when they're applying for protective orders, print out your text messages, because otherwise the judges get handed the phone, which we do, and then we'll read it into the record. So it's on the record, but it's a lot easier if I have like actual evidence to be submitted. Attorneys may know this are really pretty relaxed rules of evidence in our protective order hearings. Hearsay is admissible. Pretty much everything is admissible that the judge thinks is relevant. So we have to make a decision on what's relevant, and you also have to be careful in protective hearings because there might be, intimidation going on. We don't have giant courtrooms in city courts. So sometimes I'll call in security, just kind of stand in the back if I feel like maybe something's going to go on in these cases. You have to really control the people in your courtroom. That picture just reminded me of many injunction cases. Now, usually the protective order hearings are not like that. The injunction against harassment's like with the neighbors and people like that people bring their whole families into the courtroom. And so it's really an exercise in controlling your courtroom while still making sure that everybody gets heard. People don't know how to cross-examine witnesses. So it's something that judges have to be careful about, but you can conduct them in a safe, fair way. So these are all the outcomes that could happen at a hearing. The protective order is upheld as written. So I find that the plaintiff has proved that domestic violence has occurred or may occur, and I uphold the protective order. The defendant becomes a Brady prohibited possessor if they fit that narrow definition of intimate partner relationships under the federal law. I could modify the protective order. So let's say she added the kids, but he has a thing from Superior Court that says he gets to call them twice a week or whatever, and that wasn't included on the original protective order. I could change the protective order to say, to comply with family court orders, something like that. And then if she doesn't like it, I say, go back to family court. This is not where you change your custody orders. This isn't where you change your parenting time orders. So a lot of times you'll get that. People who are like, I want to see my kids, and we'll realize, oh, well, they have either they don't have any family court orders at all, or they have something they don't like that came out of family court. And you have to be really careful that you're not changing what happened in family court. I could find that the plaintiff didn't put on enough evidence to sustain the protective order and dismiss. These last three, we actually put into Rule 38 of ARPOP because people were having issues with it. So if the defendant doesn't appear, they had their opportunity for a hearing, and the plaintiff does, the protective order stays in place because the ex parte judge found that there was enough cause to grant the order. And the defendant will become a Brady prohibited possessor if they didn't appear and the order gets stayed in place. If the plaintiff doesn't appear and the defendant does, the protective order gets dismissed because it's the plaintiff's burden to go forward. I always tell plaintiffs, all right, this is like you're starting again. You need to put on the evidence that you put on for the first judge, and I have to find, after cross-examination and everything that you've heard. If both parties don't appear, this is where judges were. Yeah, you have a question? Nope. If both parties don't appear, the hearing is vacated and the protective order stays in place because once again, that first judge had a reason to issue that protective order. So if nobody appears, then the protective order just stays in place and the defendant has lost their ability to have another hearing because they asked for it and didn't show up. So, I was talking about family court and I thought of something else. Now I can't think of it. I'll think of it. So that's pretty much it. And I know that wasn't huge, but I was hoping that you guys would have questions because like I said, this wasn't like a judge training. It was more like, okay, this is what happens when somebody goes to get an order and this is what we have to consider. So if you have
Thanks.
questions, I would love to take them.
I have a question.
Okay.
This is
Go
Judge
ahead.
Pringle.
Hi, Judge Pringle.
I'm iPad and I don't know how to change my name. Anyway, so you're talking about guns. If the person comes to the ex-parte hearing and they say he's threatened to kill me, he's threatened to kill himself, and he has guns, but she says, well, he's never like used it or shown it to me or whatever. Do you think, I mean, I think in those circumstances, probably I would check the prohibited possessor box. What do you think?
I would, because I think that you don't have to, you can ask if they have guns. If they have guns, let's say he hasn't used that gun to threaten her, but he's strangled her, he's threatened to kill her, all the other high risk factors in a domestic violence case, I can find that he's a credible threat to her safety. And then tell them to have guns because, the research is that 5 times more likely to have a bad outcome if there is a gun at access to a gun, not just using the gun. So it's about access to a gun. So yes, I would definitely do that in that kind of a case.
Okay.
Anybody else have any other questions?
Hey, Judge.
When you,
I was
Go
going
ahead.
to ask if you could talk about when, say, an order is declined, like when someone's able to refile or what they're able to put on that order. Say it's like declined either at a contested hearing or at the initial hearing. Are they allowed to reuse what they put on that order to try to get one later on?
This is from Jessica, my advocate. So let's say at the initial hearing, I decline it. At the ex parte hearing, a lot of times with injunctions against harassment, because for example, you'll have an injunction against harassment, like sometimes someone's committed a crime against someone, right? And that's the only act that they've committed. There's no relationship between the two. That doesn't really qualify for an injunctions against harassment because it has to be a series of acts. So a lot of times we'll find ourselves with injunctions against harassment telling people, I'm sorry to tell you this, but you have to go back. And if something else happens, come get an injunction. So for example, if someone's committed a crime against you, if the conditions of release should be no contact if it's a criminal case. And if they haven't like tried to call you later or you've never seen them again, then I'm not going to give you an injunction against harassment. But sometimes it'll be like, he's done this one thing to me and I'm scared of him. He's a neighbor. I'll still say he's got to do more than one thing. So it has to be a series of acts. For a domestic violence order, like I said, I think it's pretty rare where judges won't grant that ex parte order because of you can use domestic violence has occurred or may occur. But if you come back for another order for whatever reason, you can still use the same information, probably add something else to it because otherwise you're just judge shopping. So we aren't really big fans of that, judges, that people are judge shopping, especially like we can see what happened at the last hearing, right? And so if a judge had a hearing, found that there wasn't enough evidence, then I would suggest if the person comes back, tries to get another order, that they should have some more information, whatever, they determined was missing. If you decide to dismiss your order, which we know a lot of plaintiffs do, you can come back tomorrow and ask for another one and use the same information. So if you're dismissing it, we know there's a lot of times when victims choose to dismiss their orders for safety reasons. That doesn't mean they can't come back tomorrow. Judges are not allowed to hold that against them. They can come back and do the same thing again. So I don't know if that answered you, Jessica. Yeah, okay. Judge Pringle, did you have another question? Nope, she's disappeared.
probably, but now I forgot. Well, when you do I know this isn't a judge training, but it is helping me clarify some issues. When you have the protection order hearing, both parties are there and everything, do you allow a lot of witnesses to talk, or are you just, go to basically, I have enough information here, you know.
Yeah, I think and it's funny because Judge Klotz and I are designing a training for all our pro tems and the new judges that haven't done orders before.
Oh,
Here-
good.
So that's why I will really address that. It's really a balancing act. What I learned from a judge a long time ago was invoke the rule. Because sometimes you have a whole bunch of people in their courtroom and they're all mad at each other and they're all giving each other the stink eye. So I just say, oh, I'm going to invoke the rule. That means anyone who might be a witness has to stay outside until it's their turn to testify. And that pretty much cools down. And I will let witnesses testify, but sometimes I'll ask them, did this witness see anything? Do they know anything about these specific acts? Because that's what I want to hear in my hearing, is just about the acts that were alleged, not about how this person's so hateful and they've always acted like this. And so that really clears out your courtroom when you say, hey, was this person a witness, or are they just here to tell me how awful that person was? And so that helps a lot.
Like an offer of proof, kind of.
Right, exactly.
Yeah.
So let's see. Sharon says, what if they had? So are you talking about, Sharon, in a contested order, if the defendant says they have no guns, but the victim can describe the gun?
Correct, yes.
Yeah, so this is something that we've talked about a lot. Like some jurisdictions will use in their ex parte hearings or with their advocates, use gun identification forms. And they'll ask the victim, oh, what kind of gun does he have? Do you see it here, right? And I've talked with Anna Harper from Emerge a lot about this. And because it's so hard for us to enforce these orders, we decided that we're putting the victim at more risk by asking those questions. If they come in and they say he has 4 guns and he keeps them in the closet, great. They're willing to put that on the record. That's going to get served on the defendant. I am not going to really go out of my way and say, how many guns does he have? Where are the guns? Or if I do, I will say, hey, this is going to be served on him. He's going to see that you told me that. So I think it's a really, it's just a really line to walk in our jurisdiction, because let's say I say, turn in the 4 guns that the plaintiff told me you had, and you have to turn them in 24 hours. So, and we've had this happen. And then the plaintiff comes back in and says, well, they never turned in their guns. And so I say, well, we need to refer this to the prosecutors, right? So finally, I had a detective call me and say, Judge, will you give me a search warrant because the victim says there's guns? And it's like, that's not enough probable cause, just the victim saying there's guns, right? So I feel like we're putting that victim in a position of like, you've told all this and we can't follow through. And that's why we're trying to work on these forms so carefully, these gun forms so carefully, to make sure that that we're not making promises we can't keep. Because at the end of the day, I think what I can do with protective orders, unless there's extra information, is hold an order to show cause hearing, threaten the defendant to hold him in contempt. And what we've been doing in our criminal cases where the defendant, we've had 2 where the defendant said, yes, I have guns, and didn't turn them in, and then comes in with their attorney. And I put them under oath and they say, I don't know where the guns are. I move a lot. I had one guy, I think Mike's here, but I had one guy who said that, you know, I have really bad roommates. 3 of them are in DOC. Who knows what happened to those guns, right? And there's nothing any of us can do in that case because there's no extrinsic evidence that they're hiding those guns or that they've used those guns. So, like I said, I've talked about it with Emerge a lot. And I think I've also talked about just setting hearings on all the cases that have guns, so they would immediately become Brady prohibited possessors. But then we're bringing the victims back. And without more information about the guns, then Emerge, who I rely on to help me make my decisions about the survivors, said it's just not worth it. It's not worth just setting every case for a contested hearing, because you're just putting that victim through another hearing, another, you know, having to face that person. And at the end of the day, that defendant is going to say, I don't have any guns, and we don't have to enforce it.
Not
So,
enough value. And then one other question, I wanted to ask, one of the things that we have seen here several times in the comm center is the definition of the word near. What we see in the restraining orders or what a caller will report is, he's not supposed to be near me. The paper says near me. What is near, right? Is it an interpretation by the officer or by the judge, or is it, I mean, how do we help that piece of the conversation?
yes, and that brings up, I don't see his Pierre here, Detective De La Osa is on Sidvic with me, and he hates the confidential address part of that, because now our protective orders come out with do not go to the victim's residence, confidential, doesn't have an address, and it's like, we're not changing that. And the thing with near, I think I know that that is going to be a judicial interpretation too. Like, I know I decided a case that all my prosecutors disagreed with, where the guy was next to her mobile home, but he said, hey, I have a friend here. I've always taken my cars to this place to get repaired. He didn't approach her or do anything, but he was parked in the mobile home slot next to hers, basically getting his car repaired. And she had been peeking out the window at him, and she called the police. And I thought that, maybe he did it, but maybe he didn't. Maybe he just didn't think that was near because he didn't try to have any contact with her. So I think it's a judicial interpretation. That word near is looking at the intent of the defendant, because sometimes that near is on purpose near, and sometimes it may not be. And as far as a confidential address, I know that it makes the police, their job harder. But on the other hand, these are domestic violence relationships. So one would hope that you would know where your intimate partner was living. And I have a hard time believing that you would just stumble into their new address if you happen to. So I think that was the theory of Sidvic, and the Supreme Court agreed and passed that amendment to that rule to put that confidential. It was more about protecting the petitioner, the plaintiff. Do you guys have any other questions? Like I said, the guide sheets are really good because they give everybody, you see all the things that we tell everyone when they are served. So look at those, look at the definitions. Anything else I can answer for any of you? And like I said, this is not only like a little snippet of the rules, but to me, it's like when you are not practicing in this area of law, it's kind of good to just know the steps we go through and what the judges are thinking when we grant these kind of orders, and our limitations as far as the firearms. So if that is it, then we will give you, we'll send you certificates. Let us know if you have specific things that need to be on that proof for whatever you're trying to prove, like the chief said about for the law enforcement, and we will try and make a certificate that you can get some credit for. Okay. So thank you all for coming. I really appreciate it. And I'm staying and talking.
Thank you.
Okay.